Nnamdi Kanu, leader of the proscribed indigenous people of Biafra on Thursday, told the Federal High Court Abuja that he was ready to face trial if his safety would be guaranteed by the court. Kanu told the presiding judge, Justice Binta Nyako, through his counsel, Ifeanyi Ejiofor. Ejiofor told the court that the application to restore the IPOB leader's bail so that he could face his trial was filed on April 1. We have an application for bail filed on April 1, 2019. The application was served on the prosecution and it is ripe for hearing. We urge the court to restore his bail on the grounds that the court will guarantee his safety when he comes back to the country to continue his trial, he said. On his part, counsel for the federal government, Labaran Shuaibu, who told the court that he was just seeing the process, opposed to the application. Shuaibu urged the court to adjourn the matter to enable them file the necessary processes. Delivering the ruling, Justice Nyako, who adjourned the matter till January 16, said the only way she could guarantee Kanu's safety was to keep him in the prison. She said even judges are being abducted in the country, so prison is the only safest place for him.
We looked at the application and we saw it is something that really deserves our vehement opposition, and on account of which we needed a little time to respond to it accordingly, and on the basis of which the court is adjourned. Hopefully when we resume next, the court will be able to determine on the merit of it the arguments that we are going to come up with respect to our opposition as to whether or not the court should allow such an application.
Well, you know, the application is a fireworks. So it was served immediately after the order the court made last adjourned date that revoking the bail of my client. So, and we believe that the courts made the order out of judicial. So, and because opportunity was not given to us to address the court on issues regarding his non-appearance in court and what led to his unavailability to face his trial. So we now file an application to get the courts understand the facts as it is, and also to set aside the order. So the application was served on them in good time since almost 5 months ago. And the last adjourned the matter came up, the court didn't sit, and I also brought that to the attention of the prosecution that this application has been in court and served on you, and you've not responded. So I'm surprised this morning you're saying it hasn't been served. But as the case may be, the court has adjourned it for hearing on the 6th of January 2020 because that application must be entertained and disposed of. Because the facts as regards to what transpired in my client's house on 14th of September 2017 is now coming from the horse's mouth. Because and the affidavit disposed to in Israel is now before the court, stating the facts of what transpired between him and them and the military personnel that invaded his premises. So the court now has to look at what will file before him, and also determine the circumstance whether his safety can be guaranteed. And you can hear the court say that even him he's not even safe, because since the judges are being kidnapped presently, that don't know they can't secure, nobody can guarantee the safety of another. So until when the application is held on 6th of January and disposed of, we'll not necessarily have to take.